we're all here because we are for limited government, and what most of us are seeing here is an unlimited government. And in addition to that, we see this concept of unequal treatment under the law. And so we're all fans of a constitutional republic. Can you walk us through kind of where you see in the juxtaposition the inconsistencies of equal protection under the law?
Sure.
As a beginning?
Sure. Let me first say it's a great honor to be here, and we've had such a wonderful time just in the short period of time. Loud. Okay. Must be me. We're having a wonderful time. We had a wonderful time yesterday. When I first got here, a number of people wanted to know where Rush was, but we're not I should be so lucky that we'd be a sort of a Laurel and Hardy thing, right? But let me say a couple of things about limited government to start with this, because that really is what we're all about. And one of the things that is both very important and very frustrating about this whole situation, which really stretches through the 2016 election season and where we are now, is all of us who are believers of limited government, we're always careful when people say they want small government, right? And we say, no, it's not small government, it's limited government. And what we mean by that is we need the government to be as big as it needs to be to do the things we need it to do, but those are a limited number of things. And here, we are talking about the essence of the things that we really need government to do. To the extent that we have to give limited authority, it really is in the domain of national security and also governance. It's about whether the federal government works as the way it's designed to work. And what we have had from early in 2016 forward is a situation where those two things are severely challenged. Number one, can we trust the government to give everyone equal protection under the law? And can we trust the government to use its foreign intelligence collection authorities, which are there for the purpose of protecting the United States? Can we trust the government to use them properly, as opposed to exploit them to do things like spy for political reasons? And these are profound questions. And I guess I didn't understand how profound until I had the opportunity, which I regarded as a privilege, to actually work on national security cases. By the time John was good enough to mention the blind sheikh case, by the time I got assigned to that, I had been a prosecutor for about 8 years. And I barely knew, despite the fact that I had like big mafia cases and drug cartel cases and money laundering and all that jazz, I barely knew that the FBI had a night job. But the FBI is our domestic security service. It's our internal national security agency. And the reason for that is the CIA and the NSA are essentially in charge of intelligence collection against foreign threats to the United States. And by their charters and by statute, they're not allowed to operate inside our country. So one half of the FBI's house, it turns out, and it's a half that we've become much more acquainted with in the post-9/11 era. I became acquainted with it in the post-93 World Trade Center bombing era, but we've become very acquainted with its national security side. When I first started working with them, they used to call it the foreign counterintelligence side. And it's very, very different from criminal investigation. And for our purposes, and to go to the heart of what we're talking about, the reason it's very different is when you do a criminal investigation, even though you get to go to the court privately as the prosecutor, you get to go, there are a lot of situations where you get to go to the judge to ask for compulsory, coercive process when there's no defense lawyer there to make the argument for the other side, right? You go to get, you think there's a a place where that they're using as a depot for a drug conspiracy, right? If you gather up enough evidence of that, you go to the court and you get a warrant. But the thing is, in that domain, when you go to the judge privately and get the warrant, when the agent swears to it, when the prosecutor draws up the papers, when the judge issues the order, everybody in the equation knows that they are making a criminal case, which someday is going to be out in the light of day. So at the time that you arrest people, you have to turn over to the defense the evidence that you plan to use and the evidence that you've collected in the investigation, the evidence that you plan to use to prosecute them. So there's a certain discipline that's involved in that process because you know your work is going to get checked at a certain point. And it's going to be checked by people who are incentivized, and this is the greatest thing about our system, they are incentivized to take the government's case apart. Because in our country, you don't have to prove you're innocent, the government has to prove you're guilty. And you get to be not guilty, not just because you're innocent, but because the government can't make the case. That's the way our system works. It's the envy of the world, and it should be. That discipline does not exist on the national security side of the House. Most of the investigation that is done by the National Security Division of the FBI is aimed at essentially foreign agents. They're called in the law agents of a foreign power. They are usually not American citizens, but some of them are American citizens. It's not necessarily a crime to be a foreign agent, to act in the interest of a foreign government in our country, but there is a process. If you want to be a legitimate foreign agent, you actually have to register with the Justice Department. But what the FBI is looking at in their foreign counterintelligence mission are people who are acting on behalf of foreign powers, which can be regimes, governments, or international terrorist organizations, who pose some kind of a threat to the United States, whether it's to American interest or American national security. When that information is collected, it's collected in a secret process. And everything about it is top secret. The applications to the court, the evidence that they bring to the court, the evidence that they gather if the court allows them to conduct surveillance, it's all classified. And it's classified at a very high level. And part of the reason it's classified at a very high level is a lot of these investigations intertwine. So there is always a danger that if you disclose information, you're disclosing potentially not only national secrets that we need to keep secret to protect the country, but also our methods of doing intelligence gathering, which if our enemies and adversaries knew about them, they would be able to take countermeasures, and our sources of intelligence, including most especially human beings who go out and actually do the very dangerous, often informant work that's necessary to gather information that we need to protect the United States. I happen to, in this terrorism case, have run one of the unusual prosecutions where in the prosecution we actually used evidence that was derived from these foreign intelligence surveillance warrants. It's highly unusual for that to happen. And it's a very different process than the kind of litigation that you have in court in most criminal cases. But this was this is an unusual thing. For the most part, when they gather this information, it is to collect intelligence, to analyze it, figure out what the threats are to the United States. If it's a terrorist organization, try to map the organization and figure out what they're going to try to hit next. If it's a foreign adversary, try to figure out what their intentions are and take the measures that need to be taken to stop them. But because this is the black box of intelligence, the big problem with this, and it is an unavoidable problem, there is no way that you could structure something that could fix this. And that is, they have to be able to look you in the eye and say, trust us. Because they can't tell you everything they know. And they can't tell you how they know it. And the reason they can't is because we need that stuff to be secret in order to protect the country. So here's always the problem, right? Very legitimately, you have this black box of intelligence collection. And we need it to be secret because we need it for national security purposes. Problem is, it becomes a very convenient and very tempting thing for the government to use to conceal stuff that isn't necessarily national security secrets, to conceal things that are in the nature of government misconduct, embarrassing behavior, sometimes criminal behavior, bad judgment, what have you. So we always have to tread carefully in this thicket because we don't want to inadvertently or otherwise compromise the things that we need to protect the country. But at the same time, we have to be aware of the fact that this is an area that the government can very conveniently use to cover up things that it doesn't want the public to know. And unlike the criminal justice system, it's not a process where there's eventually going to be sunlight. We get to look at their work. So that's kind of the dichotomy that we're looking at. And it's a dichotomy that's mirrored, in a way, in the two investigations that we're talking about. I want to start out by cutting the government some slack, because what happened here was kind of an unusual accident of fate that the Justice Department and the FBI had nothing to do with. I mean, for better or worse, I thought for much worse, the Democrats chose to nominate somebody who was under criminal investigation. So the FBI was going to be thrust into the politics of the 2016 election, whether they wanted it or not. There was no avoiding that. And on the other side of the coin, Donald Trump, now President Trump, put together a campaign in which he had people in the campaign who had ties to Russia. Now, they weren't people who were necessarily at the heart of the campaign, but look, he had a campaign manager for about 4 months who has a 12-year history of interaction with a Ukrainian faction that's tied to the Kremlin. And then you have this, this fellow Carter Page floating around. He's kind of a attenuated figure in the campaign, and he's somebody who had a lot of business intercourse with Russia over the years. And the twist here is he got caught up in an FBI investigation in 2013. And I want to talk a little bit about that because it's important to try to understand, at least so far as we know. And I don't mean to drive you nuts by having to continually say, at least so far as we know. But unfortunately, there's a lot we don't know. And a lot that we don't know that could be important. But at least as far as we know, the 2013 investigation in which Carter Page was implicated, again, foreign intelligence investigation, not criminal investigation, involved a situation where he was attempted to be recruited by Russian intelligence. So it was not a situation where they had him doing something affirmative, at least that we know of, to help Russia or to work with Russia against the United States. So far as we know, all Carter Page did in that investigation was work with the United States against Russia. He actually ended up cooperating with the FBI and the Justice Department in the case against the Russian spies, and a number of them, some of them got prosecuted, some of them got kicked out of the country. But he was, so far as we know, a person who was a target of Russian recruitment, not a person who affirmatively joined with Russia against the United States. However, that distinction has been blurred, not only in the coverage of him. I think we now have reason to believe it was probably blurred in the presentation that the government made to the court to get surveillance authority. But to go back to the initial point, there was no way the FBI could have avoided involvement in politics here. And there's no way that the Justice Department could have avoided involvement in politics here. You know, that's fine. It's not the first time this has happened. You know, every U.S. Attorney's office in the United States, probably every local prosecutor's office of any size in the United States has a public corruption unit, right? Political cases come up from time to time. It's a fact of life. It's been a fact of life for a lot longer than there have been United States. So the issue isn't just the fact that the government was plunged into having to conduct investigations in the thick of this politically fraught, deeply contested election. The question is, what did they do, right? How did they handle it? And they didn't handle it well. And I think, you know, we'll talk about this some more, but I don't think, and this is the most important point in terms of equality before the law, which is the main principle we're trying to defend here. I don't think any objective person can look at the way these two investigations were handled and come to the conclusion that they were handled in the same way, with the same vigor, and applying the same sense of proportionality and meeting criminal behavior with the appropriate government response. If you look hard at the Hillary Clinton investigation, what you find out is every time somebody seemed to stray near implicating himself or herself in criminality, they were either given immunity or the FBI was told to avoid areas of questioning that actually should have been key to the investigation. They didn't do what the government does in every single case. They didn't use the grand jury to compel people to produce evidence that was critical to the investigation. Almost at every pass, they didn't do what the government tries to do when the government does what it did for my whole 20 years there, which is try to make the case. They seem to bend over backwards to not make the case. Now, in the Trump investigation, which has become the Mueller investigation, this is quite a concept. When you lie to the FBI, they prosecute you for lying to the FBI. That actually was the norm, at least we thought it was the norm, until the Hillary Clinton investigation. In the Hillary Clinton investigation, it seems when you lie to the FBI, they gave you a prize, and then they gave you immunity and told you to be on your way. So at least with respect to Mueller's investigation, to that extent, we're back to what normally happens, which is the government goes out of its way to try to make the case, not to avoid making the case. But if you look at the two investigations, what you see in the Clinton investigation time and again is kid glove treatment for Mrs. Clinton and all of her confederates and subordinates who were involved in the investigation. And when you look hard at the Mueller investigation, what you see is the earth being scorched. Very big difference between the way they've approached it. And that is kind of the skeletal overlay for the thing we need to be very concerned about, which is what's going on underneath, which is basically how are the investigators conducting these investigations. And it seems that there are many irregularities in the Clinton investigation, many ways that they conduct the investigation the way they would never conduct a normal investigation. And then when you look at Trump, we now have a background of agents, because we have these texts between two participants in both investigations. There's clearly deep political animus against Trump. At first, I must say I was not particularly alarmed by that. I was a conservative lawyer and prosecutor in New York. Most of my friends were liberal Democrats. You know, I married somebody who was in the office and not near as conservative as I am. We had pretty aggressive political arguments over a beer on a Friday night or over lunch. But when you walked into a courtroom, all that stuff got checked at the door. Because in the end, it really shouldn't matter what the politics of your prosecutor or your investigative agent are, any more than it matters what the politics of your doctor is, or the guy who makes the pizza. The law is about applying, or being a prosecutor or being an investigator is about applying legal rules to facts. And it should be a fairly antiseptic, apolitical exercise. And in my experience, it really was. But I don't think you can say that about these investigations. And the fact that these guys had political attitudes is fine. Everybody in this country is entitled to have political attitudes. But once they start talking about that needing an insurance policy in case Donald Trump gets elected, that moves away from just mere political attitudes and crosses a line that should never be crossed, which is, are you allowing your political views to influence and even control your professional responsibilities as an investigator and a prosecutor? And that's what we have to get to the bottom of. And with that as the background, what we're now seeing in connection with how they conducted foreign intelligence collection, it looks like they went to the FISA court, that's the Foreign Intelligence Surveillance Court, created by an act of Congress in 1978. And it's a reaction to the spying scandals of the 70s, to the Watergate scandal, et cetera. So what it looks like they did was they went to the FISA court without the evidence that you need to get a warrant on someone you allege is an agent of a foreign power. Under our law, to get a warrant for foreign intelligence purposes, you have to show the court probable cause that the person is acting as an agent of a foreign power, which means furthering the interest of either a terrorist organization or some other regime, government, in some clandestine way. And secondly, and this is very important with respect to Carter Page, if the person you're alleging is an agent of a foreign power is an American citizen, you also have to show that the conduct they're engaging in to help the foreign power is in violation of American criminal law. So it looks like with respect to Page, number one, they did not have probable cause that he was an agent of a foreign power. They relied on this infamous Steele dossier, which is a collection of intelligence, or what are styled as intelligence reports, by a former British intelligence officer who's now in private intelligence business, a guy who used to run the Russian desk for British intelligence, who actually was in Russia for a while, but hasn't been in Russia since 1999 because he was blown as a intelligence agent. So he had to leave the country, hasn't been able to be back in the country. But he did run the Russian desk for British intelligence for about 3 or 4 years. And he has a network of connections in Russia. I don't think anybody doubts that. But what happened with this dossier, and this is before we even get into the financing of it, because I think there's been a big emphasis on how did his project to collect information about Trump come to pass, who paid for it, et cetera. That's all very important, and it's all very interesting. But to me, as an old prosecutor looking at a judge issuing a warrant, I'm not so much interested in the purveyor of the information, the person who tips somebody off to misconduct. Because I know in my career, I took information from terrorists, from drug cartel guys, from scamsters, from, every kind of, low-level person that you can imagine. It kind of comes with the territory. We always used to say, this is trite, but it's not priests and rabbis that can give you information about the mafia or what's going on in Al-Qaeda, right? So you have to go to bad people to get information about other bad people. That's kind of a given. So I'm not too whipped up about the fact, at least initially, that the information is actually coming from the opposition campaign, because you can get information from any bad person as long as you are honest about the court in terms of where it came from, and as long as you independently corroborate it, so that you're not relying on the biased source, you're relying on the investigative work of the FBI to check out the information that they've gotten. But before we ever get to that point, we have to deal with what the information is. And if you look at what's in the Steele dossier, what you find are these are anonymous Russian sources who are providing third and fourth hand or worse in terms of attenuation hearsay. You don't have anyone who is the direct witness to the event that they say is a basis for saying this guy is an agent of a foreign power. It's like an extended game of telephone, except it's with anonymous Russians who nobody knows who they really are, who they really know, and importantly, because this is intelligence and this is always important, particularly when you're dealing with the Russians, we don't know if they are intentionally giving misinformation because they know they have an avenue to get into US intelligence. We don't know if they were intentionally seeding misinformation into the intelligence agencies of the United States in order to sow discord in our society. And in fact, if that's what they were trying to do, they've done a pretty good job, wouldn't you say, right? So I think the big problem with the dossier, before you ever get to the sponsorship of it, is the fact that as a report of fact, or what's presented to be fact, as a basis to get a warrant to spy on an American, it's woefully, grossly inadequate. And then you get to the point where this screed is actually a political opposition research product which is paid for by the presidential campaign of the Democratic candidate, basically siphoned through the investigative agencies of the incumbent Democratic administration, the purpose of which is to conduct spying on the opposition campaign. Let me make one more point about that, and then maybe we'll get to the next question. One of the comebacks that you're hearing now, and this, I think this is very important, Carter Page was a unpaid Trump advisor until September of 2016. He's not really a part of Trump world. I doubt the president could pick him out of a lineup. But he was somebody who was offered up by the administration in June or July or so, maybe before that, if that slightly. He is somebody who was handed up by the Trump campaign, I should say, as a foreign policy advisor. And if you remember the way the campaign went, most of the Republican foreign policy establishment did not flock to the Trump campaign, right? I mean, to be perfectly honest, right? So they were in a spot, and they needed to hold out that they actually had people who were giving Trump advice about foreign policy. And for whatever reason, somebody decided to point to this guy as one of them. But it doesn't look like he was ever an intricate part of the campaign. We don't know what the FBI knew about that or what the Justice Department knew about that. But what we do know is in September of 2016, the people who were behind this research project leaked information to the press about Carter Page in order to create a political narrative of Trump-Russia collusion in the run-up to the election. We're talking about mid-September now, so we're talking about 7 weeks or so, right, before Election Day. So at that point, once this all comes out in the press, the Trump campaign burns Carter Page. They cut ties with him. He's no longer part of the campaign. So what the comeback you're hearing a lot from the Justice Department and the FBI's apologists in this case is that they didn't spy on the opposition campaign because by the time they got the warrant, Page was already out of the campaign. Notwithstanding that the only reason they're interested in Page is because of Trump and Russia, right? Well, here's the thing they don't tell you. once you are up on somebody's communication devices, once the court issues a FISA warrant, you are allowed to collect not only the forward-going conversations, but anything that is in your stored email and anything that is in your stored texts. And clearly, one of the reasons that they wanted to get a warrant on Carter Page, I mean, there's no doubt that they were interested in monitoring what he was doing. But I think they thought the mother lode was going to be the stored email and the stored texts, because that was where they were going to have months or weeks of back email with Trump campaign officials that was going to prove the Trump-Russia collusion. And part of all the backpedaling now is it turned out, I think, that that was a dry hole. They ended up not finding it. But I think that was what the real attraction of it was.
Great, thank you very much for that. I'm going to ask a two-part question and leave you to go as far as you like. And then, given the mic situation, when you're done, we'll just take questions. And
Sure.
Maybe I'll come out and repeat them if you don't speak
Yeah,
loud
what-
enough so you can hear it. Is that okay with everybody? We'll do that. All right, so there's a growing frustration amongst all of us about this distrust of our government officials.
Right.
You mentioned this idea that we all have a fiduciary responsibility. Some of us taken an oath for it, in the case of federal prosecutors and others that work for our government. Given that, and given some emerging evidence that perhaps even the former President of the United States was across the line in terms of the Department of Justice, the question that I hear from a lot of people is, if that's the case, what do we do about it? What can we do about it? Where does the buck stop? So that's one question. And then when you finish that, the second one is, I understand from our engagement earlier that maybe there's some emerging information, some new information that none of us know about, that you do, so we'd love to hear that.
Okay,
Okay,
great.
thank you.
Thank you.
Start with
Right.
that.
Well, I guess what we've learned in the last 36 or so hours, there are two threads to this. One of them is being pursued by the House Intelligence Committee primarily. They're looking at FISA abuse, or potential FISA abuse. And then there's a Senate Judiciary Committee investigation. There's also a Senate Intelligence Committee investigation, but there's a Senate Judiciary Committee investigation. The Senate Judiciary Committee is important, by the way, because they have jurisdiction over the FBI, the Justice Department, and the FISA court. So they're an important player in this. But they seem to have developed two things. Number one, pretty significant evidence that Christopher Steele, the British agent, probably lied to the FBI about his communications with the media about the investigation. We don't know everything yet. I have to keep saying that. But what the Senate committee, and this is basically Senators Grassley and Graham, what they've basically put out so far leads us to believe that Page lied to the FBI about whether he had these contacts with a number of press outlets in mid-September of 2016. Did I say, who did I say? Page, I'm sorry about that. Steele lied about these contacts. And that's important for a couple of reasons. Number one of the very strange circular things that they did, apparently, according to the Nunez memo, which is the memo that was put out by the House committee, is with no corroboration available of these about these Russian sources. One of the ways they tried to corroborate Steele's allegations was by saying that the same allegations had been reported in a media article, which they insisted evidently that Steele had nothing to do with. and which we now know Steele was not only the principal source for, he's pretty much the only source for. And the reason they thought, at least from what we hear, the reason they thought that Steele had not been the guy who talked to Michael Isikoff, who was the journalist that we're talking about at Yahoo, the reason that they thought that Steele was not the source was because Steele evidently lied to them about whether he was the source. I must say, if I were a prosecutor and an agent, I mean, it's always dangerous to say what you would have done that they didn't do. But I think it's very strange, even if they thought that Steele was not the source, I would really have wanted to know who the source was before I went to a court and asked the court to rely on it. And it looks like if they didn't know, if they believed Steele that it wasn't Steele, it certainly sounds like they never identified who it actually was, because now we know it was Steele. So this is yet another place, and maybe I should just step back here and give my theory for what I think happened here. This is what helps me try to understand everything that, I always want to know, why did people do, this is like an old prosecutor thing, right? But I want to know, you never get in trouble in court if you find out what really happened, no matter how bad it is. Because if you find out what really happened and you make a story or make a presentation to the court around what happened, you're not going to get in trouble, right? Your agents might not look good, you might not look good, parts of the case might not look good, but the one place you know you won't go off the rails is that it turns out that you're presenting a fantasy to the court. You try to put the truth out, warts and all. Here's what I think happened here. There are clearly people at the upper echelon of the FBI who didn't like Trump and who believed that no matter what they did, Hillary Clinton would not be charged and would become president. Let's start with why Hillary would not be charged. The decision whether to charge Mrs. Clinton or not was not the FBI's decision. The FBI, unfortunately for them, is the most visible player in this debacle, but they're not the most important player. The decision to prosecute in any case is made by the Justice Department, not the FBI. The FBI is in charge of doing the investigation, collecting the evidence. They collaborate with the Justice Department. Prosecutors consult with agents about what they should do in the investigation. Agents consult with prosecutors about whether people should be charged. But the division of authority is very clear. The FBI is a component of the Justice Department. And they're loosely in charge of the investigation. They do all of the investigative work. They come to the U.S. Attorney for strategic help, and if they need search warrants or if they need to use the grand jury, but otherwise they run the investigation. When it gets time to decide who to charge, that's the Justice Department's call. It wasn't Director Comey's call, it wasn't anybody in the FBI's call. Justice Department's call. But this is an unusual investigation. This is an investigation of what everybody knew at that point was going to be the Democratic nominee for president, who the incumbent president, saw as his successor and the person who was going to carry out his legacy. So you have to have a situation here because the president runs the executive branch. If the president doesn't want somebody charged, the person doesn't end up getting charged. I mean, it's just a fact. I mean, I know they say that there's this wall of separation between politics and law enforcement. It's a very porous wall. And it's supposed to be, because there's nothing, the framers thought there would be nothing more dangerous than having prosecutorial power which was completely divorced from political accountability, right? So prosecution and investigation are executive powers, and the reason they're executive powers in our system is if they get abused, it's the president's fault. We have somebody to hold accountable for it. And that gives the president the incentive to police and direct the executive branch, right? So that's the way our system works. We don't want to have complete independence of law enforcement. That's what they have in totalitarian regimes. We don't want that in our country. So I don't think Mrs. Clinton was ever going to be charged, but there's another wrinkle in this case, right? Mrs. Clinton is using a private email system, private email address, and we now know this homebrew server system. On at least 20 occasions, President Obama clearly, knowingly, and willfully, and under an alias, communicated with Mrs. Clinton over her email system. Now, to be clear, he was not using a private email system. He was using a pseudonymous government email address. So it was government email, but it wasn't like Barack Obama at executiveoffice.gov, It was some other name. But the point is, he and she exchanged about 20 chains of email messages. So there's no way that he didn't know that she was using at least an email address, if not a private email system that was offline. Now, when the President and the Secretary of State are having communications, they're not talking about yoga routines in Chelsea's wedding, not 20 times, right? General Petraeus was prosecuted for leaking classified information or exposing classified information. If you read the government's charge and their statement of the facts of Petraeus's case, part of what they say he exposed were notes of his conversations with the President of the United States. The reason that's presumptively classified is not only what you would common sense think the reason is, there's an executive order that applies, President Obama's own executive order. And it lays out a number of things that are presumptively classified. And among them are foreign affairs matters, the movement of troops, other kinds of military matters, national security matters, the sorts of things a president and a secretary of state would be talking about. So we can presume that there's classified information in at least some, if not all, of these exchanges. Why do we have to presume it, right? Didn't you all think that we had already gone through all of Hillary's emails? The State Department's gone through it. We have statistics about how many emails there were, a couple of thousand that had classified information in it, how many were marked classified at the time, how many were up classified after, how many were classified at the moment they were sent, how many were top secret, how many were special access program, right? You think we've done a thorough statistical analysis of her emails, right? But we haven't done an analysis of the Clinton-Obama emails. And the reason is the president invoked what they referred to as a presidential records privilege. Basically, they said, no problem with the substance of the emails, but we want to defend the important principle that the president has to have confidentiality in his communications with his most important advisors. Now, that's important for two reasons. Number one, when they said presidential records privilege, that meant they didn't have to say what they really meant, which was executive privilege, right? And they don't want to say executive privilege because that's fraught with all kinds of Watergate baggage, right? The last thing they wanted to say was we're invoking executive privilege when Mrs. Clinton was in the middle of a criminal investigation. The second reason this is important is by invoking the presidential records privilege, which is a very dubious privilege under the law, they simply sealed all of the emails. And they're sealed for a number of years. I think it could be 20 years or 50 years. I can't off the top of my head remember how long they're sealed. But by sealing them under this dubious doctrine, they didn't have to come out and say, we've checked to see whether there was classified information in them. And had they done that, and had it turned out inevitably that there was classified information, they would have had to admit that the president was transmitting classified information on an unsecure channel, which was exactly what Mrs. Clinton was being investigated for although of course on a much bigger scale than what was involved with Obama. This is a long-winded way of explaining that there is no way you could have charged Mrs. Clinton without disclosing the Clinton-Obama email communications, and without its becoming embarrassingly clear that Obama had engaged in the same behavior that Mrs. Clinton was being charged for. They would have been very important evidence to the defense, because Mrs. Clinton would have wanted to show that she was being charged for something the president had done and was not being held accountable for. And they would have been important to the government's case, because it would have been more classified information that got transmitted out of normal channels. So I think because Mrs. Clinton was Obama's, sort of the heir of the Obama legacy, the one who was going to carry it forward, and because as a practical matter, you could not have indicted her and prosecuted her without exposing those emails, there is no way on God's green earth that Mrs. Clinton was ever going to be prosecuted. Now, here's why that's important. Obama gets on national television in April of 2016 and essentially says, I don't want Mrs. Clinton charged. Now, maybe we would have said this was an obstruction if her name was Mrs. Flynn instead of Mrs. Clinton. But, you know, she's Mrs. Clinton. So the press did not say that Obama was trying to influence the outcome of an investigation and prosecution. But the important thing about it is that's statements that he made in April of 2016. What we now know is within a couple of weeks, Director Comey and his top advisors at the FBI already started drafting an exoneration of Mrs. Clinton, which Director Comey ultimately said publicly in July of 2016. But they had already decided that she wasn't going to be charged. And that was before close to a couple of dozen of the most important witnesses had not been interviewed yet. They hadn't collected up all of the important information yet. And Mrs. Clinton herself hadn't been subjected to an FBI interview. So my point about this is once Obama said in April that he did not want Mrs. Clinton to be charged, the rest is just details. The decision was already made. And I think what happened in the investigation is it was determined that she was not going to be charged, but they had a political need to make it look like there had been a searching, thorough investigation at the end of which she was exonerated. And that was the objective. But I don't think that she was ever going to be charged with a crime. So that's her piece of it. I started down this ramp on the new information. So the Nunez thread here is the one that's pursuing the FISA end. The Judiciary Committee, the Senate Judiciary Committee, is not only onto this business about whether Steele lied to the FBI about his sources. It turns out now that they have another channel that Steele fed into the FBI. And it's a convoluted story, but essentially they have information which is going through the hands of old Clinton standbys or old Clinton Confederates like Sidney Blumenthal. And the information is going from the Clinton people and the State Department into the FBI through Steele. And this is something that we hadn't seen yet. This is based on reporting that isn't in the Steele dossier that we've known up until now. So that's the new information that came out in the last 36 hours. Unfortunately, the way this thing is, between the leaks and the 3 or 4 different investigations that are going on, the different committees, we have different pieces of information coming at us all the time, and it's very hard to stay on top of it. So that's the new information. Remind me what the first question was again? What do we do about it? I knew I suppressed that for some reason. So, I wrote a book about 3 years ago that you mentioned called Faithless Execution. And the subtitle was Building the Political Case for Obama's Impeachment. Usually, when that gets told to people, they ask me, well, how'd that work out for you? But the point of the book was actually not to argue for Obama's impeachment. It was to argue that if you're going to impeach Obama, you had to build a political case for it, because the way impeachment works in our system, unless there's a political consensus that the president needs to be ousted, it'll never happen. In their genius, the framers created a system where you can impeach, that is to say, you can file articles of impeachment with a simple majority vote in the House of Representatives. But in order to remove the president from power, there has to be a supermajority conviction against the president in the Senate. And because of the way our politics works, unless you have something that's so egregious that it cuts across, that the revulsion at it cuts across partisan lines and ideological lines, you will never impeach a president. And that's fine, because the framers didn't want presidents to be impeached for frivolous reasons. They didn't want, political theater. We may get political theater if the Democrats win the midterms. Maybe they'll vote to have articles of impeachment on Trump. But the framers wanted to make sure that sort of stuff didn't result in a president being removed. So the reason impeachment is important is because, as Madison said, it's indispensable to the working of our system. Because if you don't have impeachment, then you can't hold wayward actors in the government responsible. You can't hold them accountable. And then if you're in a situation where you can't really hold them accountable, you are limited or you are vulnerable to whatever they politically think that they can get away with. That's the way the system works. I've always thought that we make a big mistake when we make our kind of criminal justice system the overlay of everything we do, including in politics and political accountability. When you have people who are corrupt actors, or even if you have people who are incompetent actors, the most important thing for our country and for our society is to remove the power from them. Whether in addition to that they get indicted and held accountable in the criminal justice system is interesting, but it's a process that takes, as we know, it's a process that takes many years. And if you're going to rely only on the criminal justice system, what you're going to end up with is, for a very long time, people who shouldn't be in power are going to be in power. And I do think that you're not going to have a good system until you revive impeachment, because we've kind of lost the discipline of holding people accountable when they abuse their power. If you vitalized, I can't even say revitalized, because we don't even have a rich tradition of any impeachment in the country. And I'm not just talking about presidents now, I'm talking about government officials who wield important power. If you don't have remedies in there with teeth that make them understand that if they abuse their power, they will be removed, and you're going to rely just on the criminal justice system, you are never going to remove people from power. I mean, it'll happen every now and then, but the Supreme Court's actually made it a lot more difficult now to prosecute people for political corruption. And the court's message to us, I think since the McDonald case, which is about close to 3 years ago now, I guess, the court's message to us is, don't come to us about political corruption. Fix the system yourself. You don't want corrupt people, vote them out of office. That's pretty much what the court is telling us. So I think we have to have a system where we hold people accountable and remove them. And here, you have, in this particular situation, a lot of the people who were bad actors, or may have been bad actors, are not even in the government anymore at this point. So it's very hard to to do anything in the way of removing power from them, but at the very least, what I think we have to have is a transparent investigation or set of investigations that makes clear exactly what happened and exactly who did what. And that makes it clear to future actors that we're taking a position that this won't stand, that this can't stand, that this is impeachable, and that the intelligence authorities of the United States are for collecting information that we need to protect the country, not to spy on your political opposition. And I think we have to have a system, if we're going to have the rule of law and the kind of flourishing society that you have to have the rule of law to have, we have to have a conviction that everybody is equal before the law. And that if you're a Democrat when the Democrats are in, or a Republican when the Republicans are in, that's not an advantage before the bar of justice. That everybody, we go back to the tradition where the Justice Department is essentially an apolitical organization. The FBI is not interested in politics, and we're just doing law enforcement, and we're just doing intelligence collection. If we don't get back to that, the biggest fear I have about this is that these intelligence powers we have, like the Foreign Intelligence Surveillance Act, and the way that we gather intelligence, the different programs we have, again, they rely on your belief when the government looks you in the eye and says, trust us, that we're gonna exercise these powers correctly. If we lose that, if we don't trust them anymore, the next move is going to be to repeal these powers or strip them back substantially. And that's the problem really with when you have bad actors in government, you got to get the actors out. Our first impulse, we never want to get the actors out, we want to strip the powers away. The problem is the powers are there because we need them in an emergency to protect the country. And if you strip the powers away, we don't have them. And frankly, a rogue is going to be a rogue no matter what the rules are. So if you make it harder for good faith, competent government officials to exercise these powers that we need, the only people who get penalized are us, because these are tasks that need to be done to protect the country. The rogues are not going to be penalized because whatever the rules are, they're going to break the rules. So I think that it really underscores that the important thing is when you have people who are abusing power, you have to remove them. And whether we do other things down the road like prosecute them is secondary.
Thank you very much.
Sure.
We'd love to go on and on and on. Thank you for comprehensive answers and a fantastic evening, but I know everybody had plans. We're past our time.
Oh, sorry about that.
Can you take a question?
Yeah, of course. Happy to do that.
Is that all right? A couple of questions? Okay. I'll just,
Yep.
You want to just stand up and answer? No, we can hear you.
If Obama, in effect, told the FBI to take his foot off the gas, it's sort of ironic that Comey came out 2 weeks before the election and did what he did with the Wiener,
Right.
quote unquote, emails.
Right.
So what do you think his motivation was on that?
Right. The question is, why would Comey come out if it was already in the bag that Mrs. Clinton wasn't going to be prosecuted? Why did Comey come out at the last minute? I think it was because they were certain she was going to win. And look, almost everybody in the country was certain she was going to win, right? There were people in the Trump campaign who were certain she was going to win. But I think they were certain she was going to win, so he wanted to be on record as having raised this so that if the alternative would have been, since Wiener was being prosecuted, this information would inevitably have come out after the election, and then it would look like the FBI had suppressed it. So I think they figured it was safe to do it, and that's why he did. I know how angry they are about that, but I think that's probably what he was thinking of. Here. Oh. Yeah. Well, the question is, where's the Intelligence Committee and where's the media? Which is kind of like the same question, right? Rush and I, the only thing we couldn't get to the bottom of He and I have actually been having this discussion for a number of years. The only thing we couldn't get to the bottom of yesterday is, I get to be political here, right?
Whatever you like.
Good. Is the Democratic Party an adjunct of the media, or is the media an adjunct of the Democratic Party? We've actually been gone back and forth on this for a number of years. The media is obviously covering this in a very different way than they would be covering it if we had the political shoe on the other foot. And it's really, I mean, it's quite astonishing to watch the media say we don't want information. But to the extent that people are out there saying, you know, we don't want the Nunes memo and we don't want, we have to protect methods and sources. Have you ever heard the New York Times worried about methods and sources of intelligence? So, you know, look, I think it looks like the government actors here were politicized, and we take as a given that the media is politicized. So I think that's the short answer on that. As far as the Senate Intelligence Committee is concerned, I'm always leery when everybody wants to cooperate with one committee to the exclusion of the others. And, you know, for whatever reason, the Intelligence Committee is viewed by a lot of people who are in the middle of this investigation as the committee that's really sort of establishment Washington. And they're not terribly worried that they're interested in that committee in anything else other than whether there was Trump collusion with Russia. And that committee is, look, the committee is very close to the Bureau, it's very close to the intelligence agencies, and I think it would prefer not to be investigating them. They're happy to do the investigation as long as it's about a foreign affairs thing, but I don't think they're that interested in going after the government actors.
Yeah, I've met a lot of people here.
Why don't you,
Okay.
so you won't have to repeat it then.
Two questions. One's real easy. Maybe I'm the only one who didn't know this. How do these judges get appointed to be FISA judges? Are they Article 3 judges serving on a per diem basis? Nobody knows who they are.
Okay.
And the other question is, the predicate to the comments about the rottenness at the top of the FBI from conservative commentators is always, we respect and admire the people in the field because they're all straight shooters. Organizational, not just politics, but organizations generally, people percolate to the top by reflecting the views and principles of the organization they represent. My question is the whole agency rotten?
Okay. Start with the FISA court. The Foreign Intelligence Surveillance Act was enacted in 1978. The purpose of it was to create some due process for Americans who were suspected of being foreign agents. So the court, I can't remember now if it's 11, there's probably people in the room who know this better than I do. It's either 11 judges or 14 judges are in the FISA court. They are all Article 3 judges. They all have a day job. They're in their own districts doing their own cases. They have 4-year terms, and they're chosen by the Chief Justice of the Supreme Court. But they're all Article 3 judges who are sitting on federal courts. As far as the FBI is concerned, look, I may have a soft spot either in my heart or my head. And it could be my head because I told people, Jim Comey and I started out as prosecutors together like about 30 years ago. I think I'm about like 5 minutes ahead of him in the office. I was sure, I confidently told people that he was going to do the right thing in the Clinton investigation. That if there were crimes there, he would move on them. And then flash ahead, my other brilliant observation to people was that you can be sure there's absolutely no way ever that the FBI would bring to the FISA court information that hadn't been verified or corroborated. I confidently told people what you're going to find is Steele's name won't even be in the application, because what will happen is they'll have mined a few allegations out of there. The Bureau will then do what the Bureau does and scrub it to make sure it's corroborated and credible, and that's what they'll bring to the FISA court. They won't stick a caption on the Steele dossier. They'll do what the Bureau does. I'm wrong on that too. So every time I've come to their defense, I've been My record is not real good. But I still have great confidence that the FBI is one of the great institutions in this country, and that the people who work for the FBI are, look, I worked with them for 20 years. They're the salt of the earth. I mean, they're patriotic, and they're good people, you know, and they are in the job because they care about the country for the most part. I mean, there's obviously a lot of other reasons for it, but I think with this particular class of people, what I've always found is a high level of patriotism and dedication to the job. I think there are people in high-ranking positions that made mistakes, or worse, and that's why I tried to start our discussion tonight by pointing out that they were thrust into this through no fault of their own. It's not like they went around hunting for a political case to be in, but that said, once you're in a political case, your job is to conduct it like you would conduct any other case, and they didn't. So I like to think that to the extent mistakes were made, it's at the upper echelon and it'll be dealt with. I'm not ready to write off the FBI. I think it's a great agency. Yep.
And kind of following up on the last question, as I try and think, so many questions I could ask, but as I try and think of motivations and organizationally how this might have played out the way it has, and as you've discussed, the one thing I'm really having a real hard time getting my arms around is, I guess it's Mr. Orr, Bruce Orr.
Yep.
And how his wife could work for Fusion GPS and he remain on the case.
Right.
So,
Okay. You guys are going to love me by the end of the night because I was in the U.S. Attorney's Office in New York, which we always arrogantly called the Sovereign District, not the Southern District, with Jim Comey, with Bruce Orr, and with Mike Horowitz, who's the, we didn't even get to Mike Horowitz tonight, right? He's the Inspector General who's doing the investigation on what the FBI did in 2016. So I feel regret having to talk about these guys because I know them all for a million years. But the Bruce Orr thing, first of all, he is not formally assigned to the case. So his job in the Justice Department is actually a very, very top job, or at least it was in this period of time. The way the Justice Department works, essentially the Deputy Attorney General runs the Justice Department day to day. You know, the Attorney General is doing a lot of other things and is the main cabinet appointee, but the day-to-day work of the Justice Department is basically run by the deputy is kind of the CEO, right? Bruce Orr was the deputy to the deputy. So it's hard, unless you're in one of those two very high-ranking positions or a handful of other ones, it's hard to imagine somebody acting at a higher level of the Justice Department. That is, though, why this is all the more alarming, because what we now know is Bruce Orr's wife is working at Fusion GPS, which is the outfit that Steele is retained by to create the dossier, right? Orr's wife is a Russia specialist. She's actually collaborating with Steele to write the dossier and to do this whole project. While she's doing that, Orr is actually talking to Steele. And his office is like next door to Sally Yates's office, who is the Deputy Attorney General. It would be a waste of time to look for a paper trail there because you just need to walk down the hall, right? So you have a situation where you have a very high-ranking Justice Department official of the Democrat Justice Department under circumstances where they're being fed information by the Democrat candidate through the offices of the wife of someone in the high-ranking in the Democratic Justice Department in order to get a spying warrant on the Republican campaign. It makes it very bad. I mean, I don't know, how better to describe it. His role is very disturbing. It should be pointed out, he is one of these guys who they refer to as a career prosecutor. So he started out as a, assistant U.S. attorney in New York. He made his way, as many of them do, down to the Justice Department. He's worked in administrations of both parties and climbed up the ladder through then. So he's one of these guys, and this is pretty frequent. He's known to have left of center political views, but essentially that shouldn't make any difference in the Justice Department. Nobody really cares what your political views are as long as you're competent at your job. But when you seem like you're acting on your political views, or in our system, because we want the system to have integrity, it's not just whether you were acting, but whether there's an appearance of impropriety. Because we want people to accept the outcomes of our system, of our justice system, so they have to not only be honest, they have to appear to have integrity. So I think for his purposes, it's a very serious lapse in judgment, not only to have done what he did, but to have done it under circumstances where anybody with an IQ over 11 would have realized this looks awful. So.
Senator Bishop, you get the last question.
Thank you. Why is FBI leadership then still stonewall? As to say, they appear, that's got to be as evident to them, more evident to them than it is even to any of us. So why are they blocking and stonewalling? Even the new director, Ray, is that his name?
Right.
Trying to prevent that release of the media.
Well, so here I'm going to go back to the the question is, why is the FBI stonewalling since it's now Trump's FBI, right? Why would they be trying to cover up what happened here? And I'm going to go back to the caution I started with, which is that there's a lot we don't know. But let me float some educated speculation. Number one, what seems to have happened here is a real black eye for the FBI. I mean, if they went to the FISA court, they keep telling us that there's more stuff there than the Steele dossier. But the deputy FBI director at the time, McCabe, apparently testified to the Intelligence Committee that without the Steele dossier allegations, they could not have gotten the warrant. So we know they relied on it. They keep telling us that there's a lot more information there. I have a feeling what we're going to learn is there's a lot more innuendo about Carter Page, but nothing that's really solid. If there was something solid on Carter Page, this was 2013, the investigation he fell into. It's a 5-year statute of limitations in federal law. If he did something wrong, they'd have prosecuted him by now, I think. But what else goes in a warrant, and what was their theory? So it's not just, when you do one of these FISA warrants, they tend not to be just information about the target of the surveillance. They also pad it with a lot of information about the foreign power and what the foreign power is trying to do and what the foreign power's objectives are and the threat that's posed by the foreign power. There are a lot of people, and I think they're right about this, in the Justice Department and the FBI that are legitimately concerned that if these FISA warrants and the successor ones after the first one, there were 3 reauthorizations. Every 90 days they have to go back, right? There's a lot of legitimate concern that if you put it all out there, it is going to compromise not only methods and sources, but important intelligence secrets that we have about Russia that we don't want them to know we have. So that's one problem. The second problem is nobody wants to look bad, and the FBI is going to look bad as this unfolds. I think they actually would look better if they just once and for all came clean and put it out there. That we always, when we prepare witnesses as prosecutors, what you tell them is, isn't it a fact that you robbed the First National Bank on 10 o'clock in the morning on Wednesday? The answer to that question is yes. The answer to that question is not, because then it becomes, well, you went into the bank that day, right? And you had your gun with you, right? And you saw the teller. And did you frighten her? And basically, if it's a death of 1,000 cuts, they will look worse if this comes dribbling out a piece at a time. I think they'd be better to just come out and say what happened. But they're likely to come out with a black eye on this. The third thing, and I'm now going to engage in the same kind of innuendo that I'm criticizing them for, but I'm going on what the reporting says. Their theory with respect to President Trump, which is the theory in the dossier, is that Putin was trying to blackmail Trump and had the goods to blackmail Trump. And I have a feeling that if they put all the information that's out, it's going to float out what their theory was of why Putin would be able to blackmail Trump. And that's something it could all be wrong and could all be false, but that doesn't mean the White House would like it out any better, right? So for all those reasons, good ones, bad ones, political ones, I think they're not in a hurry to put it all out.
How about a round of applause?
Thank you. Thanks so much.